The state of Rajasthan is in appeal against the judgment of learned single judge Rajasthan High Court, Jaipur Bench, Jaipur, holding that there was non-compliance with the mandatory requirements of Section 50 of Narcotic Drugs and Psychotropic Substances Act 1985. In short, the Act. Stop. The said conclusion was arrived at on the ground that though the accused respondent had been given the option of being searched in the presence of Sri Satendra Singh, PW3, the Deputy Superintendent of Police, he was in essence a member of the raiding party and therefore the search in his presence cannot at all be said to be in consonance with Section 50 of the Act, though he was a gazetted officer. Background facts in a nutshell are as under colon dash. On 8/9/1995, Prem Sekhar Meena, PW2, SHO Police Station, Kotwali, Baran, having received information about illicit trafficking in narcotic substances, rushed to the place pointed out by the informant and apprehended the accused respondent Satendra Singh. SP PW3 also reached there, subsequently being of the suspicion that accused respondent was in possession of contraband. The SHO informed him of his right to have his search conducted either in presence of Sri Satendra Singh, SP PW3, who was a gazetted officer and happened to be present there, or in the presence of any magistrate. The accused consented for his search to be conducted in the presence of the SP PW3. On being searched, 570 grams of opium was recovered from his possession in the presence of Ramesh Chand PW5 and Rajendra Kumar PW6. Out of the recovered opium, a sample weighing 30 grams was taken and was sealed. The remaining opium was also sealed. The accused was accordingly arrested. White arrest memo Exhibit P5 and memo of recovery was prepared. The SHO thereafter registered a case wide FIR Exhibit P4 and deposited the recovered opium in the Malkhana during investigation. The police recorded the statement of witnesses and sent the sample to the forensic science laboratory. On chemical examination, the sample contained in the packet Mark B gave positive tests for the chief constituents of coagulated juice of opium poppy having 5.43% morphine. After completion of all these formalities, the accused was charge sheeted under sections 8 and 18 of the Act. The trial judge framed charges against the accused under sections 8 and 18 of the Act, to which the accused denied and claimed trial. The learned sessions judge Baran held that the accused was guilty, convicted him in terms of sections 8 and 18 of the Act, and sentenced him to undergo 10 years rigorous imprisonment with a fine of rupees 1 lakh with a default stipulation of 1 year's rigorous imprisonment. In appeal, the main stand of the accused respondent was that there was non-compliance with the requirements of sections 42 and 50 of the Act. The High Court held that since the accused was searched on a public road and the contraband articles were seized, Section 42 of the Act had no application in view of explanation appended to Section 43 of the Act. It was noted that Prem Shankar, who was an authorized officer under Section 42 of the Act, informed the accused of his right to be searched in the presence of the Deputy Superintendent of Police PW3.